Three.
I'm Gregory Demopoulos. I've been an attorney in Michigan since 1988, and this short video is going to be some of the basics about getting a divorce in Michigan. It's for informational purposes only because the facts of your case might not fit exactly what I'm talking about, and no attorney-client relationship exists by virtue of this video. So a common question is, how long does it take to get divorced? In Michigan, if you have minor children, there's a 6-month waiting period. If there are no minor children in the case, there's a 60-day waiting period. Oftentimes, a court, for good cause, will waive the 6-month waiting period if the parties are settled, but it would not be any earlier than 60 days. A divorce case starts by a plaintiff filing a complaint for a divorce. If there's no minor children, the court will get a $150 filing fee. If there are minor children, it's a $230 filing fee. The complaint for divorce gets filed, and in that document you're indicating whether or not you want custody or joint custody, how you want your property divided, whether or not you want spousal support. At the time of filing, you can also ask the court for a ex parte order requesting custody and child support. Sometimes judges will want to have a hearing on that. Some judges will just grant one when you file. So that's a judge-based kind of thing. Once your divorce is filed, we then would serve the defendant. The defendant would have 21 days to respond if it was personal service, like through a process server, or 28 days if it was through certified mail. After that process, discovery starts. Some cases don't need discovery if there's really no assets to speak of. Other cases require discovery, so both parties make full disclosure of their assets and liabilities. About 60 to 75 days into the process, the court will hold a status conference just to see where the parties are, to see if there's any services that the court can offer to help settle the case. Oftentimes a judge will order a case into mediation if the parties are having difficulty settling. Sometimes they'll order a custody evaluation or a parenting time evaluation where a recommendation is made. After that process, the court will have a settlement conference. If the parties aren't settled by that time, a lot of times the judge will assist the parties in trying to settle, and oftentimes will give clues to the parties as to how a judge might view the facts of a case and how the judge might rule on the case, which oftentimes helps the parties settle. If the settlement conference doesn't work, then your case would be set for trial. A little bit over 95% of divorce cases are settled prior to trial because the judge will, as indicated, will try to settle at the settlement conference. Cases go to mediation. Mediation is a very successful tool at resolving cases, and it allows the parties to have some control in the outcome. When you go to trial, the judge has total control in the outcome. If you have any questions, you could give me a call. My phone number is 734-844-1400.